explain what I mean. Okay, let me come back to that. Let me just go to the rest. Then on paragraph 6.1 under deliberation, we say none. And I don't understand that. But I mean, how can the deliberation be none if, this entire document or this entire analysis is a deliberation? Then on page 13, is this 13 or 41? Right. So what I found lacking in the cover submission is what are the implications to the applicant if the tariffs for the 26-27 financial year are not approved, as we have in this case. I mean, I think that is important to include that write-up on the cover submission so that we can understand the full implications of our decision as NERSA. And then also, the implications of what tariffs now apply to the applicant for the 26-27 financial year, if what they're applying for is not something that we prepared to approve. So I looked at the reasons for decision, and you do cover it. I think you say that the 22-23 financial year tariffs will apply, but I think the cover submission also needs to, close that loop. And then on page, I think this is page 34, this is in your reasons for decision. So paragraph 4 correctly quotes the non-discrimination rule, but the submission is silent on whether the proposed tariffs were discriminatory or not. And I think this is important for us to cover. Where the proposed tariffs found to be discriminatory, I think we should cover that. And then I noticed here that we make reference to the 24-25 financial year. This is on page 35. I was just wondering whether NatCos has provided us with their actual tariffs for the 24-25 financial year, just to have that information. And then my final comment, Chair, relates to the applicable law section in the reason for decision. So I think we must elaborate on that applicable law. I think the way it's currently captured is deficient. I would like to suggest to the team that we include the provisions of Section 28(5)(b) of the Petroleum Pipelines Act, which states that the licensee may request the authority to review its tariff from time to time and submit a proposal. And importantly, Section B, the existing tariff remains in force until a new tariff takes effect. So this closes that gap between, okay, so what tariffs apply to the applicant in the event that this approval is not approved. And I think this is important because this subsection is the legal basis for the recommendation to keep the old 22-23 tariffs for marine loading and wide product storage. So I think it's very important that we expand on that section. Those were my comments. Thank you, Chair.
Thank you very much, Madam Governor. Madam Massetti, over to you, ma'am.
Thank you, Chairperson. Chairperson, I just want to start off first with the way that we are framing who the applicant is. I think we just need to deal with that part. There's some inconsistencies in the way that we are writing who the applicant is here. And maybe it will be useful to indicate who the licensee is. Who did we license for the infrastructure that we are regulating for this purpose? The storage the assets as well as the loading facilities. So we need to understand who did we license, and also in terms of the PPA, it goes with the ownership as well as who we license. So we need to just be very clear here. I know that we mentioned two, Sasol Oil as well as Total Energies, and then somewhere we're saying that NatCos manages the operation. And then we also go on and mention NatRef. And then in one sentence, we'll say that NatCos is unincorporated JV. And then it is also managed by the incorporated JV and all of that. So there's a bit of confusion, even from the very title of the document. And then you go to the worst one is the way that we frame it, 1.1 and 2, the purpose as well as the subject matter. So if we can just sort that out, Chairperson. I wanted to just start there. And then the second thing, Chair, that I wanted to get to is the I'm looking also at the timelines that we have here. We have an application that we received in November 2025. It has taken too long because this application in the first place, or these tariffs, should have been effective as of 1st July 2025. And these are pretty straightforward in the sense that, I mean, this is an approval. It's not even the setting. Yes, the information will still require that in the information to do thorough assessment. Chair, I think your mic is on. There was a sound coming from your side. So looking at this table, the timelines or the turnaround times are really not looking good, Chair, for a matter such as this one to have taken so long. It's over 6 months, and the team is only bringing this even after the date when these tariffs ought to have been approved already. If we had approved them, they should have been applicable on 1st July 2026. I think it is something that the team needs to look into, and not really, even if we take 6 months to process these, I think we need to ensure efficiencies around the turnaround times. Then there's the third issue that I would like to come to is the fact that I think if we look at the way that we talk about the approval of the tariffs in 2020, 2022, 2023, those tariffs, even at that stage, they're problematic in many areas, and resulted in excessive increases of around 379% increase, as well as 287% increase for the storage facilities, as well as for the marine, for the loading facilities. That on its own, I mean, to have such increases that are quite excessive, it tells us that the team ought to have gone back and thoroughly analyze the information immediately after the approval for monitoring purposes, and making sure that audits will then be done to do verification and all of that. But we're not getting that kind of information as to what happened. And even at that stage, we picked up that there was incorrect calculation on a number of areas, one of them being the allowance for decommissioning or the rehabilitation of land in terms of the regulations. But what did we do to assist this licensee even from 2022 to date? I think it is something that we should have dealt with, and also these excessive increases is something that we ought to have looked at. Then from that time on, we get application on for 2024. Again, that application was not approved. Was not approved because they included, which is fine, they've included the rehabilitation of land. Yes, we did not approve, but what did we do again to assist this licensee so that it can submit a compliant application? 2025 is not listed. Maybe we can complete the picture there by adding 2025. What did we do in 2025? Now, Chairperson, looking at the economics of this, especially with very high prices, when we have a duty to make sure that we approve cost-reflective tariffs, number one. Number two, we make sure that we allow costs that are prudently and efficiently incurred. Now, with the 2022, as things change, with 2022, how do we make sure that, I know that we are rejecting this, but I'm asking this question in relation to the unintended consequences of the provisions of the PPA that we are citing or that we rely on, that the tariff that was previously approved will be the one that the licensee will be using. I don't think that was meant to be the tariff that must stay for another financial year and another financial year, all of these financial years since 2022. That could not have been the intention of that provision at all, because then it means it will make us fail to make sure that the tariffs that we approve are cost reflective to start off with, and that we are allowing a cost that prudently and efficiently incurred. I'm sure that part is meant only in situations where there is a gap between us taking the decision for the next cycle of the tariff, as opposed to each financial year now will rely on tariffs that were approved, say, 4 years or so ago. I think we need to look into that carefully and see if really this was an intention. Otherwise, then we are allowing the licensee to go on with the tariffs that in the first place were increasing around 379% and 287%, which already was an issue on its own. And then, Chairperson, I just wanted to go on to the last point. Yeah, the last point that I have is the clawback on table 3. And my question is, how did we calculate this clawback? What is it based on? Because in the first place, we never got things right. I mean, we have documented 2023, 2022, 2023. That was some years ago. And then, and thereafter, there's no information that shows that we have done audits and we are basing even this clawback on audited financials, having done the verification, having dealt with the excessive increases that we have seen. Now, this clawback, how do we know that it is understated or overstated, and whether this shall be the clawback in the first place, as we have not determined what are prudently as well as efficiently incurred cost. And we can't be certain that this shall be the accurate figures for the clawback, and what are they based on, when in fact for 2024 we did, or 2023, 24, 25, we are relying on the old figures, and nothing has actually changed. That will be my last point, Chairperson. Thank you very much.
Thank you, Madam Maseti. Mr. Sibanda.
Thank you, Chair. I think probably I'm largely covered by colleagues. I'll probably raise one or two other issues. The first one for me is probably a general one that perhaps covers not just this application, but all the applications that we deal with, and that's the calculation of the work. And I'm looking at table 5 on page 29. So the cost of capital obviously is one of the important calculations that we do. However, what I don't get is we don't explain our approach or how we've calculated the various work parameters. So, for instance, an applicant will come up with a calculation for their beta. We do ours and come up with a different value. Other parameters, cost of debt, CPI forecast, and all of those. But we don't explain how we've approached or how we've calculated those parameters and arrive at a different work value. So perhaps if I could be assisted there, Chair. Because I mean, we do, for instance, talk to other issues, whether it's operating costs and all of that, but when it comes to the work parameters, we don't seem to get to the bottom of how we've arrived at the different values. And then when it comes to OPEX on page 30 of 41, I think it would help. Well, maybe my first question really is, we are comparing 24-25 to 26-27. What happened to 25-26? So there seems to be a gap there. And yeah, perhaps we should have included a forecast for 25-26 as well, before moving on to 26-27. But on table 7, it would also help to have to show the percentage difference between our calculation and that of the applicant, for both the loading and the storage facilities. And then I think the issue of the clawback has been raised by Ms. Massetti, but maybe if I can also talk to it from a different angle. It's quite late to be calculating a clawback 3-4 years down the line, because effectively what you are doing is, if there are new customers, they end up bearing the brunt of tariffs that were determined years in the past, and the clawback that's only being implemented now. So you're transferring that burden to future consumers of the product, and I don't think that's fair. I know it's probably not of our own makings, because the applicant did not, or the licensee did not apply for a tariff perhaps in those intervening years. But I think we need to come up with a way of dealing with that. If an applicant does not apply for tariffs in the intervening period and comes in years later, how should we be dealing with the clawback? Should we just be treating it as normal, or should there be some punitive measures applied? But I don't think we can just accept it as is, because it becomes unfair to current customers or consumers. I think perhaps the issue around the timelines that has been spoken to, and I'll probably just stop here, Chair. Thank you.
Thank you, Mr. Subanda. Advocate Stoll.
Thank you, Chairperson, and thanks to Ms. Boko for the presentation. Chair, mine is a point of enhancement which relates to public consultation processes, particularly on page 22 under decision-making process, Chair. Chair, especially paragraph 17 is not really clear, because when we publish a document to solicit input from our stakeholders, the stakeholders can submit their input in writing or request to make oral presentations. But when you read the paragraph, it's not clear as to whether we did get the written comments, and based on that, there was nothing really to address. And secondly, the oral presentation, we did not get any request. But that paragraph 17, the way it is, it just goes to say that there were no requests for oral presentation in addition to public comments. Whether we had, the way one can read that paragraph, it seems as if there were written comments that were received. However, they did not also warrant any additional requests for public presentation. And you may read it differently as well. So if that can be enhanced, Chairperson, we start by mentioning the fact that following our publication to solicit for comments from our stakeholders, we did not receive any written comments, and as well as any request for oral submissions. And we close it in that particular manner, and it becomes clear to a reader that we have given the stakeholders the opportunity to either submit their comments in writing or a request for oral presentation. So that paragraph, Chairperson, can be enhanced to make it clear to a reader. Thank you, Chair.
Thank you very much, Madam CEO. Madam Bowen, team, I'll give you a chance to respond. Please note, and I think EM, just make sure that you underscore certain comments and even questions for continuous, part of your continuous improvement efforts, make sure that they're not applicable just to this, or applied just for this submission, but that kind of get embedded in all similar applications, so that we really are improving and indicating that we are taking this into consideration and improving, becoming more effective. Issues of lines. I won't repeat it. The issue of timelines, indicating percentages for better comparison from one period to another, leaving no gap between no gap between the years, if there are any, just to be able to account for it. Also, please assist to ensure that with regard to the issue of consultation, you clearly indicate, like paragraph 17, that there were no comments received by the closing date. And then you go on to then also say that there were also no requests for oral representations in addition, so that you then could not hold the public hearing, just to make those clear. Also, when it comes to who the applicant is and all of that, those are some of, just mentioning some of them, that we are very clear on this, and we incorporate them in other similar applications. With that, ma'am and your team, may you please respond.
Maybe, Chair, if I'm sorry, Ms. Bogot. Maybe, Chair, if I may start and appreciate all the comments that have been shared by. Sorry, I got. And indeed, we note the comments and the enhancement. We will consider those. And just the few clarity, if we may, I see that Mr. Untit has posted some messages on the chat, but if we may first allow him to talk on the licensing and clarify that before we get to the parts on other questions. And also just to clarify that in terms of the template of the submission, the deliberation normally refers to whether the matter has been deliberated before by members or in any committee. In terms of the subcommittees that we have, then we highlight those deliberations there, which then allows members to refer to those deliberations and how we have addressed them. So that is the template that we use as part of our IRM division. And also in terms of the timeline, the ideal situation is that we have workshops with the licensee so that we clarify the submission before it comes to us. However, with licensees that have been submitting before, they normally submit and then we have to then deliberate on the application. If you may go through the timelines, you'll see a number of assessments that have been done and inadequate information being declared and having to go back and forth. And the final acceptance of the application was around February. So we try by all means to ensure that we process the application in less than 6 months or even 5 months at some point. But I think at some point we were deliberating whether we should rather reject the application outright and then they reapply, so that we are not seen as being sitting with the application for such a long period, because there is an option for them to clarify and have a workshop before, so that we are able to get an application that is ready for processing. And then in terms of I think one of the questions from Ms. Govender, we've had a situation where in the past for 6 or 7 years when I came to division, we had licensees with the tariffs from 10 years ago, and we've had a project where we have written to all the licensees and try and make them to apply and have recent tariffs, and also ensuring that there's I think latest through the help of the FCRM as well, ensure that they apply for multi-year tariff. So no, it's not standard procedure that licensees will have old tariff. It's one of the projects that we've been working on, and I think we have worked on more than 80% that they have the latest tariff. However, they will still have a situation where there's a gap in terms of the years, and I think that's also addressed in terms of the point that Ms. Maseti raised in terms of having a current and cost-reflective tariff. So we do engage with our licensee to try and ensure that those gaps are closed. So, Chair, if I may quickly allow Martin to talk to the who is licensed, and then Ms. Bogo will then come in and address the other question. Mr. Undit.
Good morning, Chair and members of the public. I've did put on the chat box, this is all public information from our website, but just to maybe make it more clear is that Sasol and Total is unincorporated and they were issued a license jointly. However, and maybe it's just we could improve on that, and we will, Ms. Masetti, the confusion that NATREF, which these partners operated, that is in fact an incorporated JV. So maybe we can just improve or should be improving just the way we've put. But subsequently, and this is also public knowledge, when Prax took over the share from Total, the license was amended, but it still remains Sasol and Total Energies for the white product, and remaining as joint facility. If I may then just also speak to what Ms. Govender asked in terms of the period. I think the tenure, the last 3-4 years, uncertainty about the tenure was part of the problem why there was delays in some of these aspects and further investments. But you can see from the capex that they've spent, the maintenance on those had happened, and it also reflects in the tariff application, but no further expansion. And now with Section 79 being clarified and in place, I think that has been addressed. So we trust that we will not have a situation where there's uncertainty for 2, 3, 4 years about this. Thank you, Chair.
Thank you, Chair. I'll deal with the other questions. I'll start with Ms. Govender's questions. The first one relates to the applicable tariff being owed, in that it was approved in respect of the 2022-23 financial year. And the concerns were raised by members regarding this tariff being owed and not cost reflective. And there was also a question on whether this is consistent with the Petroleum Pipelines Act. Chairperson, I think we are limited by the Act in that for petroleum storage and loading facilities, we can only approve a tariff that is applied for, as opposed to pipeline facilities where, irrespective of what the licensee applies for, we can then set a tariff in line with the prescriptions of the tariff methodology in place. So this has been a challenge. I think members have also seen that this is not the first application to be rejected. And we have noted the request from members to also talk to the impact of the decision we are proposing not to approve in this case in the cover submission. And members, I do agree that there is an adverse impact on the licensee side if the tariffs are not adjusted on an annual basis or regularly, especially regarding their maintenance obligations and attracting investments into the sector. So yes, there is that impact, and then in this submission, we'll enhance it to also demonstrate the impact to the licensing. But then in terms of what we can do, we are limited to either approve or not approve what is applied for. And the tool we then use to assess the application is the tariff methodology. And in respect of what Sasol, as the lead applicant for this application, has done, so there are inconsistencies in terms of aligning to the prescriptions of the methodology, especially regarding the calculation of the land rehabilitation cost, as well as the taxation element of the allowable revenue. So those are the things that led to disapproval or the recommended decision to not approve the application. And Ms. Gavenda also asked if we have a strong justification for the recommendation we are making. it is solely relating to the application of the applicable tariff methodology, where the licensee had not applied the methodology to the T in determining especially the costs for land rehabilitation as well as the taxation element, because those are the biggest contributors to the differences. Martin and Ms. Mutua have touched on the issue around incorporated JV, so I'll leave that as well as the deliberation section of the cover submission. I think the point around the implications to the applicant, Ms. Gavenda, also relates to what I've admitted to enhance on the submission, to just talk to the implications of the recommended decision on the cover submission. And this is something we'll also do in future submissions as well. Members have also asked what tariffs then now applies. And we also need to, we have done the indication in the decision and reasons for decision document, but there's guidance to then also close the loop and the cover submission to clearly indicate what tariffs would apply. We'll also do that. And with regards to that element of discrimination, there is a minor error there, Ms. Gavenda. We're supposed to talk to the actual tariffs for the period under review, where licensees are supposed to indicate what actual tariffs are charged to their customers. One, because the approved tariffs are really maximum tariffs, which in most cases are discounted by licensees in application. So what that section 21 of the Act requires is that in discounting the maximum tariffs, licensees should not discriminate on unfair grounds. And then we will also clarify that in the submission, and just correct that 2024-25 typo there. And we are also guided to enhance the applicable law section to include the provisions in section 25 of the Act, and that it should be aligned to the recommended decision. So talking to the applicable sections of the Act in line with the recommended decision. So we'll do that, Chairperson. I'll come now to Ms. Masete's questions. I think Mr. Untit has spoken to the issue of applicants. We'll also of being clear in terms of who we have licensed and who the applicants are. We'll also enhance the submission to ensure that it is clear and we refer to who is licensed in terms of the licenses issued by NESA. We also note the concerns around the timelines. And I think with regards to this particular licensee, keeping in mind that the lead applicant here is Sasol, who files application almost all the year, like every year for the past number of years. So some of the areas were really not expected in terms of these applications. But I think we also explained in another meeting with members that there were inconsistencies, especially relating to the tax element and the land rehabilitation contribution calculation. And our plan, members, is to engage Sasol because they normally would file around November or December. But then we want to have a pre-application meeting with them early this year to go through all the inconsistencies and then ensure that we clarify the requirements of the new methodology. Because in the past, their understanding of the methodology was aligned, leading to approval of tariffs in most cases that are applied for. So that is the plan. And another anomaly with this particular application is that the other party who is perhaps is really was not always available to provide additional information that's required, and that has led to delays. And I also do admit to our own internal bottlenecks, especially relating to the approval of the ER implementations after the confidentiality decisions are made. We also had delays internally within NASA, and that is something that would need to be addressed at an organization-wide level. And we will see how we engage the powers that be to assist with that. And also, Chairperson, in terms of the rules, we needed to publish the applications for like 30 working days, which is in most cases about like 1.5 months. So even the compliance processes in themselves are long for us to always do the applications under 5 months. So it's not always possible to take it from adequacy to decision day within 5 months, but then in some cases we try and we are able to do 4 months. So yeah, those are just my comments regarding the delays, but we continuously want to look at ways of enhancing our efficiencies as a department as well. Coming to the comment around clawback, I'll also couple this with Mr. Sbanda's question or comment on regarding clawback. Our calculation, members, is really based on the actual audited information for the 2022-23 financial year, which we compared with the projections that were made by the licensees then to then get to that clawback value. And we take to heart the recommendation to come up with ways of addressing the lateness of applying for clawback by licensees. And this is probably something that this is something we'll also look into in the review of the tariff methodology, which is currently underway. So we'll take that into account. But then for Ms. Masedi, just to give you comfort, the clawback calculation is based on the actual audited costs for that 2023 financial years. So before calculating clawback, we always make sure that there is audited data to base the calculation on. And then coming to the CEO's enhancement, noted member will enhance accordingly. I think Mr. Mkhize also spoke to how we'll do that. Thank you very much.
Thank you, Madam Bogo. EM, do you still want to have any say before we go on?
Thank you, Chair. I think I'm covered for that. I think I've also posted something on the timelines, which also include internal processes that we need to try and reduce. And I think there have been attempts to try and run other processes parallel to try as much as possible to reduce the number of days. But we're also going to learn maybe from other division how they do it, so that we always try and make sure that we fast track the processing of the application. Thank you, Chair.
Thank you. I think when you're dealing with these matters, please also consider and clearly articulate that the prevailing tariffs will the current tariff will prevail in the event of a tariff not being approved or not applied for. The legal framework was foreseeing a situation where there's a general increase from an inflation point of view, that you will have tariffs in subsequent years a bit higher than prevailing ones, all things equal. And therefore, that alone being an incentive for licensees to continually apply for new tariffs. But we know that that has not been the case, and that is why you have had, to write to licensees requiring of them to apply for tariffs. And I think you have spoken to that project. Please, I think it's important to outline it in the opening or background statement. And that when it comes to the times, just make sure that you account for the timelines. So you need to also articulate the enhancement of the pre-application engagement. I think if you can just talk to that, because there is a consideration that this is a applicant with vast experience, and maybe you kind of put your part down there. But I think that becomes very important because it eliminates some of these things, differences at a technical level. And the fact that you are looking at multi applications with reopeners going forward, because it's going to, in terms of efficiencies. If you can just please outline that, and also state clearly, Madam Bogo, as you stated in the verbally, that you are using actual audited figures. Hence, then the need to consider just making sure that that is clearly outlined, and one doesn't have to kind of read between the lines. That is all that I would say needs to be done, and I think that it's important that you also talk to the issues of the work parameters, the work, because you're not indicating there to say what's the difference, what's so different between what you have and what the applicant has. If you can just, I think it's a matter that you can quickly talk to. And I think as well as the OPEX, the page 8 of 41, where you're looking at the comparison, you did talk to it, but where you refer to the audited figures. Can you please just explain the approach on how you calculated work or work elements or parameters as opposed to the applicant? Over to you, Madam Bo, just quick on that, and then we can go back to the members if they are covered. Also, I just want us to move towards the decision. Thank you.
Thanks, Chairperson, and apologies. I really missed going through Mr. Sibanda's other questions. Regarding the work, the reason for the difference, Chair, here is not exactly the fact that there's different approaches being used, because the licensee used the data we have published on the website. However, in peaking the relevant period, which should be 12 months before the commencement of the tariff period, they made an error and picked wrong data or data that was available at the time the application was lodged. And then coming to the principles, and we take the guidance to be clear in terms of how we are, what approach we follow in determining the weighted average cost of capital. So it is a weighted average cost of capital for cost of debt and cost of equity. For cost of equity, we use the capital asset pricing model. And then the proxy we used for the market risk premium is the JSE, and the proxy we used for the risk-free rate are 10-year government bonds. And then the proxy we use for beta is international companies that are in the oil and gas sector. And members will recall that a while back we did come with a submission to talk to the selection of proxy companies there. And then we use those variables to calculate the capital asset pricing model as a cost of debt element, right? No cost of equity element. And then for cost of debt, we normally use the licensee's actual cost of debt, and then we determine the real post-tax cost of debt using the CPI as well as the tax rate, corporate tax rate of 27%. And so yes, that is so in instances where an entity doesn't actually have debt, we then use the prime interest rate as a proxy for the cost of debt. But then in future submissions, we'll just provide that detail of how we determine the elements. Thanks, Chair. Coming to the OPEX, yes, Chairperson, I think what we missed including in that table is the 2025-26 financial year, so that we are indicating the accurate increase from that base. And by now the licensee does have the costs, even if it is the latest estimate. So we'll just enhance that element and include it. Thanks, Chairperson. I think that covers everything.
Members, if we may proceed to the decision, but before then I saw Madam Masetti's hand. May just come in, covered on this.
Thank you, Chairperson. Just so that the reasons for decisions are adequate, Chair, number one. Number two, that we don't expect that then the matter ends here. We should expect compliance with the conditions of license, that they submit a compliant application. So since we have powers to approve, and now there's a huge difference in this one, we expect them to amend their application so that they can be able to submit a fully compliant application. So the guidance is quite important, so that they know what areas did not satisfy the energy regulator. So I wanted to find out, Chairperson, about the timelines with which we expect this applicant to comply with the Act by submitting a fully compliant application for assessment. That's the first thing, Chair. Especially because they have been struggling since 2020, I would say November 2025 with this application. I think it's important that we do determine the timeline so that we get them to now comply. Then the second thing, Chairperson, that I still have a problem with is the fact that let me start off with the clawback. With the clawback, we are using the FY23, which is your 2022-2023. Yet we do have audited financials by now for 2023-24 and for 2024-25. So for 3 years, we do have audited financials. They should be available. So the question is, with the figure that we have, which is the 2022-23, like financial year 2023, what about the financial year 2024? What about the financial year 25? Which we ought to have looked at that clawback and see what then happened so that we do a reconciliation. That part we did not do. We're simply taking FY23, which is your 2022-2023, yet we do have audited financials for 2 more years after 2022-23. So that for me is inadequate, because then we should be able to do proper reconciliation and be satisfied that by 2026, where we are, at least we looked at the audited figures for those years, and now we are satisfied that reconciliation has been done, and this is the accurate figure, having taken those years into consideration, and that doesn't come out of the submission. And I believe it is inadequate sitting in 2026 taking this decision without that particular information having been mentioned what happened to it. So that is the first thing. And then the second thing, I do want to emphasize the regulatory risk that is embedded in the continuous use of that section of the Act for a period of 4 years, when our own regulatory framework, which is the methodology, and even the Act, it requires us to allow prudently incurred as well as efficient cost. So then it means our assessment does not go far enough to make that determination of whether the costs that are before us are prudently incurred as well as efficient cost, because all we do, we simply take what appeared to not be efficient in the first place, given those increases of 300 and something and 200 and something percent, which were not efficient. And now we are moving on with those calculations for a period of 4 years. So I am a bit worried about that. And I think the team must also make sure that check the critical assets that are supposed to be the asset ring fenced for the JV and the services provided by the JV, and not take assets maybe that are also utilized by the individual licenses themselves. I do want to emphasize those, and I believe that with these areas on the clawback and the fact that we have all of these years, it is a regulatory risk, and to a certain extent, it will go against, even with the calculation that we have done. Yes, we are not approving, but still it does not take away the regulatory risk that are embedded in this matter. Thank you.
Thank you. I think the issues of regulatory risk and are noted for enhancement in also looking at them very rigorously in the application to be lodged by the applicant henceforth. I think the matter of the timelines, Madam Maseti, we can leave that as a operational matter to be dealt with and then reverting to this committee. I'm saying this particularly noting that the partner to Sasol Oil in this case has had to also undergo some business rescue and other developments in the space, which can affect the timelines, but at the operational level, those matters are to be dealt with by the division. We know that in the energy and particularly liquid fuel space, in some changes, I think some of you have heard recently of the Shell downstream being also taken over. So there are these developments that could also impact. I think that's why it's also going to be important, Madam Boko and the team, to ensure that you also indicate the users of these facilities, just to paint a picture in this regard, working closely with the licensing counterparts within the division. I don't know if you want to have the last word, and then we can move to the decision. Madam Boko, in your team.
Thanks, Chair. Just a short one. With regards to submitting a compliant application, given the concerns raised regarding the tariff being now old, we will add a section in the decision document to compel the licensee to file the application within a month or 30 days or so. And the 3-year leg relating to clawback is also something we'll engage the licensee on, keeping in mind that we have requested them to now file multi-year tariff applications. So there's also need for us to ensure that that clawback or the clawback for 3 years is not just claimed in one financial year, but smoothed through over the 3-year period. So we'll also talk to that. And I think we'll also, in the analysis of the application to be lodged, go a step back and talk to the adjustments in terms of the assets that were licensed for this facility, which led to that huge increase, even in that 2022-23 financial year tariff. So we'll do that extensive assessment so that we talk to issue of prudency of cost and then the justification for those increases and assess whether that is efficient and prudent. Thanks, Chairperson. Noted.
Thank you. I will keep the issue of the lodgement operational matter, because there should be extensive pre-application engagement, and therefore not just to say it's a month, it's this. We have to look carefully at the timelines, noting also the issues that I've raised, but we're keeping that as an operational matter. And we make sure that we've got all the figures, there are no gaps in the years, and I'll clearly outline that we've got audited figures. With that and the enhancements that are going to be made on the application, members, by show of hands, if you support the recommendation as read out in the record. Thank you, Mr. Sbanda. Thank you, Madam Massetti, Madam Cavender, Advocate Stolle, Mr. Machola. This then dispenses of item 5, taking us to item 6. Over to you, Madam Toa, and your team. The Rima Vuso allocation mechanism for uncommitted capacity for a storage facility located in Secunda, Mpumalanga province. Over to you, ma'am, and your team.
Thank you, Chair. I'll quickly ask Mr. Mapodi to introduce the submission. Thank you.
Thank you. Good morning, Chair, and members and colleagues. The purpose of the submission is to request the PPS to approve the allocation mechanism for third-party access to the Rima also investment P2LTD Petroleum storage facility in Secunda, Mpumalanga province. On 19 May 2026, Rima also investment submitted its allocation mechanism, and the allocation mechanism was assessed for compliance with all the requirements of Regulation 8 and meet all the requirements of Regulation 3.8. Also noting that Rima Wuso investment is a new entrant player in the industry. In its allocation mechanism, Rima Wuso investment also stated that the facility will be allocated to customers on a first-come, first-served basis by applying the use it or lose it principle as prescribed by the regulation. It is recommended that the Petroleum Pipeline Subcommittee approves the allocation mechanism for uncommitted capacity for the licensed Rima Wuso investment petroleum storage facility, and also approve the publication of the allocation mechanism on NERSA to be placed on NERSA website. Thank you, Chair.
Thank you very much. I know that we're not doing so well in terms of time, members, but I think the preceding submission was good to engage extensively on, noting that we have a relatively short agenda, as well as the fact that it is also precedent setting in a way with regard to a host of other submissions of the similar nature to follow. Please just be economic with time in responding, commenting, or guiding the team with regard to this submission. Any comments, questions, guidance in this regard by show of hands, members, please? Thank you, Madam Cavender. Over to you, ma'am.
Thank you, Chair. Thank you to the team. I just have a few questions to ask on this. So, on the issue of timelines and compliance, based on what I've read, it looks like the license was issued on 19 May 2025. And in terms of Regulation 3.6, it requires a licensee to lodge the allocation mechanism within 6 months. So I just would like confirmation from the team. Has this been strictly complied with? And if not, why have we not taken any enforcement action? So I picked up from the submission that this lodging of the allocation mechanism, in one part of the submission, it says it's supposed to be lodged within 6 months, but in another part, it says 1 year. So, for example, in paragraph 5.10, you say 6 months. So I wasn't sure about that. Which is it? Is it 6 months or 1 year? And why is there that discrepancy? If I understood that correctly. And then the issue, obviously, of the non-compliance. Today is the 8th of July. I just wanted to understand, are we doing anything about the fact that the timelines were not complied with? Then my second comment relates to the third-party access, use it or lose it principle. How does this allocation mechanism give practical effect to this use it or lose it principle in Regulation 3.9? And are we able as NERSA to put any safeguards in place to prevent the licensee from hoarding capacity or favoring, any particular affiliated companies? So I just wanted to get a sense of, practically, how do we have examples of how capacity will be allocated to third parties, on reasonable commercial terms? Then a comment on, are we able as NERSA, is there something within our regulatory capacity to ensure that these allocation mechanisms actually result in increased third-party access and better utilization of the storage infrastructure? Or do we simply take it to be the case on the strength of relying on the word of the licensee? So in other words, do we have any capacity to measure the outcomes? And then, this is on page 65. You have a date there that says 2nd of June 2026 for the application of the construction license. And then you say the site visit was conducted in May before the construction license application. So please recheck that paragraph because something looks off sync there. Because I think the application for the construction license was lodged in June, and then you say following that you then did a site visit in May, but obviously May comes before June, so maybe there's an error there or I may have misunderstood it. And then my final comment, Chair, is on the issue of monitoring and enforcement. And so I just wanted to get a sense of what monitoring and enforcement has occurred where mechanisms are non-compliant or ineffective. And I relate this question to paragraph 5.26, where we say that 59 out of 64 have lodged their allocation mechanisms. So I just wanted to get a sense of how we monitor and enforce, non-compliance. Thank you, Chair. That's all.
Thank you, Madam Governor. Tole.
Thank you, Chairperson, and thanks to Dr. Ramapoli for the presentation. Chair, mine is just one question of clarity, which is to just check with the team if we, as the regulator, get an opportunity to comment or give input on the agreement between the licensee and the third party before it is actually finalized. I do note the fact that issues of third party are based on the licensee and the third party. However, they need to comply with NESA governing legislation and regulatory tools. So my point, or rather my question, is that do we get that opportunity to engage the parties before they finalize their agreement, such that we ensure that all of the provisions in our governing legislation and regulatory tools are taken into account into the agreement? And this, I'm asking, it would assist really in minimizing some of the challenges that we tend to have on issues of non-compliance with third-party access. Chair, I will stop there in terms of my question that seeks clarity from the team in terms of our processes. Thank you.
Thank you, Advocate Stolle. Mr. Mapoli and your team, may you please respond?
Can I come in, Chair? Thank you for the questions and comments, members. Timelines. We'll double check the 1 year versus the 6 months, Ms. Governor. There was transitional arrangements, but I think that might have been a typo there, because I think it was actually shorter for existing facilities under the transitional arrangements, but the regulations does stay 6 months from the issue date of the license. So indeed, not compliance. This is a new entrant, and onboarding some of the new players into the sector. We do workshops, but they do from time to time require further assistance, and then we follow our compliance procedure, the PPR. But we have stated to this committee that is a bit generous in terms of the number of reminders and the escalation process. And as we speak, that process to actually review the compliance procedure to not be so lenient in terms of the number of reminders before it's escalated will be drastically reduced, and that will be coming to this committee very soon in terms of the revised procedure, which will put more pressure on them to comply. So we did have a workshop with them. Then the reminder process is followed, and we then directed them to apply, which they then responded to. In terms of the practical effect, use it or lose it, it's a valid point. That is the terminology in the regulations, and we've also discussed this with the department in terms of the party that published these. In terms of hoarding, it's practically difficult. We rely on inquiries from third parties and or complaints lodged. And we also got the procedure where parties request third-party access. They must copy NERSA, and then we monitor those processes to see that it happens. So we do monitor them if they copy us, which the majority does, but in the beginning did not. So that's the way we then can see if there is challenges. In terms of it coming to third questions, it's just take it, or do we just take it, or do we measure it? I think firstly we do take it, and we've got standard guidelines which we also has published to guide them on what is the minimum requirements. But then over time, the practicality has proven that we largely do rely on what the licensees tell us, except for when we go do site visits. And then there's also the requirement to submit volume reports. So during the volume reports, we also then look for third parties. And if the third parties then obviously is there, we can also check with them if there are challenges in terms of the getting the access. Page 65, yeah, I think we could have done better in the wording. What's happened is originally to force them to comply with the tariff application, because the original tariff application was also not meeting the requirements. There was engagement between the team, the tariff team, and the licensee. During that process, it became evident that they also wanted to do add some more tanks to the facility, expand the facility. And that is when the site visit then took place, and therefore the actual formal lodging of the application came later. But yeah, we will improve the readability of that. Then your question about the enforcement, the 5964, that process has been slow to start off, but after our guidelines, we've come up from 64% to 85% to the current 92%. And just post the submission of this document as part of monitoring and enforcement, one of the others also lodged it. So there's now 60. That one will be coming to PPS in the next meeting. So we're now then sitting at 94%. We have also used the full-time member lately to also engage at the top level with two of the non-compliant parties. And I must say that also responded resulted in we getting the documents submitted literally the same day after that meeting. So that is also the part of our strategy. Advocate Story, in terms of do we have sight or do we have opportunity? I think the short answer is no. The commercial agreements is normally dealt with between the parties. However, if there is, again, disputes or the facilitation of such, we do. But yeah, I think the short answer is no. We don't have opportunities in terms of that. However, as part of once the license is issued and the monitoring of the actual tariffs charged, then we do request those agreements, and we then get sight of them. But maybe we can improve or do it differently in terms of doing it up front. We'll also be guided by. And then my last comment relating to your question, CEO, is that with Section 79, which applies in the port of Durban currently, but will be extended to all ports, that will necessitate that we re-look at allocation mechanisms and how it is formulated and what information is in there following the ministerial directive, which will need some changes to specific facilities. But yeah, this facility is an inland facility, therefore that will not apply. But just for the record that we will have to, it also links to Ms. Govinder's question, or whether we just accept it. I think going forward, we'll have to look case by case, and in the event of being a coastal or import facility, then the whole thing of the guaranteed capacity for new market participants that will be flowing from Durban will have to be considered. I trust I've answered all the questions, Chair.
Yeah, I think it's important to cover the issue of June versus May. We verify that, but there could be instances where there's a in loco or fiscal site visit prior to the lodgement of an application. such that you could have a visitation or before the lodgement, or there's a lodgement, then the team goes to verify some of the things on site. That could happen. And then on the issue of monitoring and enforcement, it should also be borne in mind that the Act is kind of light-handed, noting that it has not been also amended since the Act 60 of 2003. We're now in 2026, and work is underway in terms of amending legislation, which will also look at tightening some of the issues of monitoring and enforcement, noting that you've got to write compliance letters, 4 warnings. There's nothing like spot fines there, all of that. So that will contribute. And I think it's important just to if you can just put some of these things in the background going forward, so that it helps to clarify this. Also, how we monitor, just at a high level, just that one liner, because the questions that members are asking actually should be used in a progressive manner to improve the submissions, such that the questions raised today don't get raised in future. You preempt them. With regard to third-party access, again, just to you could have just an indication that it should be borne in mind that where NERSA does not participate in commercial arrangements between parties, but would be able to assist where requested to advise in terms of if these agreements are in compliance with the regulations, and that we would take action as part of compliance monitoring and enforcement in verifying if these agreements are actually in compliance with legislation. You know, in some instances like the LPG facilities in the Western Cape, there was an issue raised, although that issue ended up being addressed before the Competition Commission. Just wanted you to just incorporate that in submissions going forward. I think I'm covered. I don't know, Madam CEO, Madam Deputy Chair, Interim Chair, are you covered?
Thank you. I'm covered.
Thank you very much. With that, members, you covered. Thank you. With that, we have the recommendation before us. So there's also another thing that I think I need to highlight. Madam Governor, I just forgot in the last one. When it comes to the issues of these deliberations, I also was first a bit confused that there wasn't anything included in deliberations. But deliberations, normally in this submission, they include what was deliberated upon previously, not necessarily what is a new deliberation. So normally when there is something is coming for the first time, you'll find that under deliberations there isn't any substance put there. Just wanted you to note that. With regard to the recommendation, it's on page 9 of 29, which is under paragraph 15.1. It reads thus: it is recommended that the Petroleum Pipelines Subcommittee approves the allocation mechanism for uncommitted capacity for the licensed Rimavuso Investment Petroleum Storage Facility, and the publication of the allocation mechanism on NERSA's website. By show of hands, members, if you support the recommendation. Thank you, Madam Kavenda, Madam Maseti, Mr. Majola, Mr. Sbanda. I also support. Thanks also, Advocate Tole. Thank you very much, members, for all your inputs, your questions. and also your insightful guidance to the team, which has helped us to dispense of these 2 items. For my side, thanks also to the team led by Madam Mtwa, as well as also the other members of this of staff and management at NERSA who are here, always assisting us and working as a team in dealing with all the issues that needs our attention as the regulator. So for that, I'd like to thank all of you. I'd also like to thank the members of the public. Just by merely following us, it pushes us to do better every day. So thanks, and allow me to declare the open part of this meeting closed. Have a blessed day.